Namaste, I'm Dr. Shweta Chaudhary, Assistant Professor in Mewar University. In this, we will discuss about Industrial Dispute Act 1937 under Industrial Relation and Labor Enactment Act. So first, I would like to give you a brief introduction of labor legislation. So basically, labor legislation consists of laws enacted to govern the relationship between employer, employees, and the government concerning wages and working condition and industrial relation. And the purpose of this act is to protect workers' right from exploitation and to promote a fair treatment in workplace dynamics and to maintain an industrial peace and boost overall productivity. The importance of Industrial Dispute Act, we can say that it created to prevent and resolve dispute effectively. It even ensures mutual understanding and harmonious relationship between employers and employee, which is vital for economic growth. Now we will discuss the objective of the Industrial Dispute Act 1947. The first one is prevention of dispute. Basically, establishment mechanism like works committee to address grievances before they escalate. Then settlement of dispute, use of forms like conciliation officer, board of conciliation, and industrial tribunal to mediate and resolve dispute. The third one is workers' protection. It prevents unfair dismissal and ensures workers' basic rights. The fourth one, the promotion of industrial peace, like it fosters an environment conducive to sustain industrial activity. The last but not the least, regulation of industrial action, which ensures that strikes and lockout are lawful and regulated to prevent disorder. The various key definitions under the Act, like for example of industries, we can say any activity involving employers and worker in organized sector for goods and services production. For industrial disputes, we can say disagreement related to work, work condition, dismissal or employment terms that involves employees or workers. The third one is workman, defined as an individual employed in a trade or business, excluding those in managerial or administrative role. Workers' Committee, a platform for employers and workers to discuss day-to-day workplace and issue, and it even prevents disputes. Then we have conciliation officer. So it's basically government appointed officers who are responsible for mediating disputes between workers and employers. Then it also has a board of conciliation. So basically these are temporary boards set up for resolving specific dispute where conciliation officer cannot mediate successfully. Then we have labor court and industrial tribunal. So judicial mechanism for handling complex dispute that requires legal adjudication. Then there are various provisions for settling industrial disputes. The first one is voluntary arbitration. So both parties agree to resolve disputes through a mutual chosen neutral third party. There are compulsory adjudication. If arbitration or conciliation fails, the dispute goes to labor court or industrial tribunal for mandatory settlement. The third one is negotiation and mediation. So in this, it encourages open communication between workers and employers to reach a amicable agreement. Provision on strikes and lockouts. So first is strikes, which requires 14-day prior notice to ensure legality. It even prohibits during ongoing conciliation and adjudication proceeding. Then we have lockouts, which where employer must follow similar notice procedures to strike regulation. In illegal strikes and lockout, any action taken in violation of procedure is deemed legal and it is even punishable. So fine, now we will learn about layoff, retrenchment and closure. So in layoff, a temporary suspension of work due to circumstances like material shortage or breakdowns where workers are entitled to 50% of their wages during layoff. Retrenchment is basically permanent termination due to redundancy, where workers receive compensation equal to 11 days' work per completed year of service. Then we have closure. It means permanent shutdown require government approval if more than 100 workers are affected. There are some penalties and offences under the Act. The first one is violation of provision, which means fines or imprisonment for legal strikes, lockdowns, or non-compliance with order. Failure to implement awards are also punishable. So punishment for workers for implementing settlement or tribunal awards. For false settlements, fines for providing false information to authorities. There are various benefits of this act. The first one is industrial peace. Basically, it minimizes strikes and it even promotes stability. Fair workers' treatments. It protects employees from exploitation. Through this, they can have economic stability as it encourages uninterrupted industrial growth. And then last, we have harmonious relationship which build trust and cooperation between employers and employees. There are some challenges and limitation. First one is delay in disputes resolution, as lengthy legal procedures are there. We have like limited scope which exclude unorganized sector workers. Employer resistance means employer may attempt to circumvent the law. Lack of awareness is there as many workers are unaware of their legal rights. There's some recent developments and future outlook. In this act, the first one is Labor Code on Industrial Act 2020, which consolidates law like Industrial Dispute Act for better clarity and enforcement. Digitalization, use of digital platform as speedy resolution for speedy resolution, and we have the inclusive of informal workers which aim at exceeding labor law benefit to informal sector. And for future outlook, we can say the modernizing labor law to meet current economic and industrial challenges. Finally, I would like to conclude that the Industrial Dispute Act 1947 is integral for resolving industrial disputes, ensuring fair treatment, and fostering peace. Thank you.